Hello, welcome. It's Thursday. I'm so excited. It's my favorite day of the week. Why? I know you're like, well, but Friday. Because Thursday, you have to look forward to Friday and Saturday and Sunday. Now, I'm not one of those people that only looks forward to the weekend. I look forward to days. I look forward to everything as much as possible. Don't get me wrong, my life isn't perfect. I still have things that aren't my favorite, but I look forward to things like this because I can look forward to life. I look forward to spending time with my family. So, if today we're going to talk about copyrights versus trademarks, what you need to know, these are things that you need to think about, how to build your business, how to make sure you're protected in your business, because there can be some pretty big consequences if you don't think about this stuff before it's too late. And we'll talk about that. So I don't want you to think that, this is something you can just wait on because, well, you don't have the money. This is one of those things that you want to spend the money as soon as possible. In fact, I was on a phone call the other day where someone was like, well, when do you think I should do it? I'm like, I'm not sure if I'm sure about this business idea. And I'm like, you know what? You need to do it as soon as possible because intellectual property typically is first to file. Not always, but generally speaking, it's first to file. So that means if you wait, put it off, somebody else could technically steal your idea, file, and you're out of luck. So it's not ideal. If you're new here, and that's what we're going to talk about, but if you're new here, my name is Taylor Darcy from Think Legal, where I help you create the business of your dreams. So welcome. Feel free to check out my website, thinklegal.law, not .com. I'll tell you a fun story about that. My podcast, Tactical Startup. You also get those live, or not live, you get those episodes on here as well. But if you want to listen to them in the car, which, I hope that it would be useful for you. I'm having a new podcast episode drop today, I believe. It'll be either today or anyway, it'll be soon. Tactical Startup is the podcast that goes with this channel. And then also feel free, if you're interested, reach out. Love to chat with you. Love for you to come on and answer some or ask some questions. I'm here to answer them. So looking forward to getting to know you in any way that you feel or that you need. All right, well, let's get started. And if you're joining us, feel free to leave a comment in the chat box of where you're from, what you're interested in, any questions that you might have. Again, I'm here to help. I'm here Monday through Friday, except for holidays. And, occasionally I need a day off. But for the most part, I'm here Monday through Friday to help you answer legal questions about your business. If you have a legal question, please, I mean it, ask in the chat below. I'm happy to answer them. And more importantly, you might even get an episode all to answering that one question. So, keep that in mind that I'm here to help you and that I can do that for you. So let's get started. Number one, a copyright is you copyright literary works. Now, it's a very broad classification. So literary works can be construed as a lot of different things. I know most people think of, a novel or a song. Those are accurate. However, there's one other interesting idea that has been posed before, and that's a literary work could be software code. Yeah. So maybe you don't patent the work that you're doing. Maybe you copyright your source code for drafting it. It's a great way and an inexpensive way to get intellectual property protection. Now, keep in mind, intellectual property is just that, intellectual property. It's not a physical, tangible property. It doesn't exist outside of typically people's minds. So this is not something, it's not a a vehicle. It's not a house. It's not an iPhone. Okay. The physical product of an iPhone is, you have rights to that as well. We're not going to get into the bundle of sticks argument for rights and properties, but intellectual property is an intangible good. And in this instance, a copyright is, again, a book, a poem, something that comes out of your mind. Okay. And so you can copyright, fun, your software source code. If you're a programmer, hey, great. You've got a really inexpensive, because copyrights are pretty inexpensive, way of protecting yourself so that people can't use that. And there's all sorts of ways that you can use copyrights to your advantage. So it's a literary work. A copyright you get naturally simply by producing the work. However, this is the big however, the registration is not required to receive some benefits, but registration is required to receive full benefits. What do I mean by registration? Registration, you have to go to the U.S. Copyright Office and file the copyright, showing that you thought of that thing first. Okay. Now, what's the difference? If you have some rights but not all rights, if you publish something of your own mind and free will, blah, blah, great, awesome, happy you did, you get standard copyright rights to it. You don't have to do anything extra, except for you only get, if there was a lawsuit, you only get what's called actual damages. So, for instance, if you publish a book and someone copies your book, okay, but you didn't file that copyright, okay, then if the book is $15, then that's the most that your lawsuit can reclaim, because you didn't copyright the book. You didn't file the copyright. You didn't register it. So in order to get the statutory damages that come with everything, you have to register your copyright. And in litigation, that's just the next step. So can you get an inherent awesome copyright? Absolutely. It's super duper easy. You just publish a work. Don't have to actually register it to get the beginning portion of it. However, to get the true value of a copyright, you're going to want to publish it. It's relatively inexpensive and it's relatively easy. $35 and up gets you a copyright, depending on what it is. At the Copyright Office, it'll mark down everything. Now, that being said, you're going to want to do it right. So, my best recommendation is find an intellectual property attorney to do the work, okay, to make sure that your copyrights are correct. Is it going to cost a little more? Yes. Not going to say otherwise, but it's better than continually submitting a copyright incorrectly, okay? Because if you submit it incorrectly, then you're just wasting time, money, and you won't have the copyright till it's done correctly. So keep that in mind. Also, keep in mind that the Copyright Office and the USPTO Office, United States Patent and Trademark Office, for those in case you didn't know what that was, they take time. This isn't something you can do today and get the benefit of it tomorrow. You want to do this well in advance. Case in point, patents can take years. Trademarks can take years. Okay, not typically, but they can. So, for instance, the minimum time period is about 6 months for a trademark. So this isn't something you can just wake up one morning and decide to do it and hope for the best. You want to think about this well in advance. You want to plan to do your trademark at the appropriate time. And we'll talk about that in just a second. So keep that, you want to make sure that you're not just willy-nilly going about it and hoping for, like I said, hoping for the best. Because there are, unfortunately, copyright trolls and trademark trolls that will try to screw you out of your intellectual property. It's terrible. It's illegal, but they still try it and they still do it. So for a copyright, for the way that it works is you get the author's life plus 70 years. So if they live to, okay, for instance, I'm not telling you my age, but if I live to 50, okay, then it's 70 years on top of that. So that's 120 years. Yay! So that's way longer than a trademark, okay, and way longer than a patent, okay? So that's why it's very important that you think about this in strategic, because it's a lot better to have a copyright in some instances than a trademark. And the reason why that's important to remember is that not everything can be copyrighted that can be trademarked, and not everything that's trademarked can be copyrighted or patented or any of it. They are very specific. So you have to worry about those things. However, work for hire is 95 years from the date of publication. So if an employee produces a work underneath your company, then the copyright is 95 years from when you publish it. So whenever that is, read that into what you will. There are other exceptions and other minutiae. We're not going to go into those details right now because it's not important for you to know. So a trademark, on the other hand, is 10 years. That's it. That's all you got, 10 years. And then it must be renewed. If it's not renewed, then it can be considered abandoned or form of it canceled in that respect. So this isn't something that you just sit on. You trademark it once and you never get it again, or you never have to worry about it again. You have to trademark it and then renew every 10 years. And there's a good reason, and we'll talk about that in just a second, as to why you're going to want to do that. So a trademark is typically a design, a logo, a phrase, a distinctive mark, a name, or a word. So, Apple, the Apple logo, a specific type of design, a phrase. Trying to think of a good phrase that makes sense. A distinctive mark. So it needs to be special. It can't just be, for lack of a better way of saying, a line on a page. Okay. It needs to be something that shows uniqueness, shows the different part from somebody else, some characteristic that makes it special. So, for instance, in trademarks, Apple, okay, Apple's a great one. It's easy to remember, and most people know who Apple is. Apple has both the name trademarked, Apple, okay, and the logo. You have to trademark both. So it's something that you want to pay attention to. And then if they have a phrase, which I can't think of what their phrasing is. If anybody knows Apple's catchphrase, if you will, then please go ahead and put it in the comments below. I'd love to. I can't remember it off the top of my head, but if you can remind me, that'd be great. But anyway, so you can also trademark that phrase. Okay, so Nike, just do it. There we go. There's a good one. Nike, here, this is probably the best one. Here we go. So Nike has the swoosh, trademarked. Nike has the name, trademarked. Nike has just do it, trademarked as well. So right there, Nike has 3 trademarks for its name. Okay. Now, trademarks are for property or personal, or not property. Yes. Products. Okay. You can also do what are called service marks for service businesses. Like, for instance, me, I'm Think Legal. I'm going to get a service mark for my business. So just because you have a service and you don't have a product, then you can do a service mark for that as well. And the same thing goes for, you can do, like, for instance, my phrase is, your success is our business. So that would be something that I would put that I could trademark as part of my intellectual property for my business. So you want to think about that type of thing. Is that, again, Nike is the best one that's popping out at me. Again, if you don't know Apple phrase, please, by all means, let me know. So Nike, swoosh, the name Nike, and then also the just do it. So those 3 things are part of Nike's intellectual property portfolio. They probably also have trademarked the name Jordans. Now they've patented the design. Okay. That's how intellectual property works together. Okay. Now, the next thing is you're going to want a trademark is about brand name. Okay. Joe's Plumbing isn't really a brand. Sorry. Rescue Rooter is a brand. See the difference between those two? Rescue Rooter has more value than Joe's Plumbing. Okay. And so That's what you're doing with the trademark. You're protecting a person's brand. Now, there are very different classifications when it comes to this. First and foremost is arbitrary and fanciful. It's most favored, which is like Reebok or Apple, and because it's easier to recognize. There's no potential for confusion because Reebok is Reebok, right? Nike is Nike. Suggestive, chicken of the sea is an example of that. Chicken by itself doesn't mean anything. Of the sea doesn't really mean anything. Together they make something, but it doesn't really, it's not fanciful. It's not arbitrary. So it's harder for them to trademark that. I'm not saying you can't do it. I'm simply telling you that's why like Joe's Plumbing doesn't really work because of that reason. Okay. Joe. Okay. You're not going to get exclusive rights to Joe. You're not going to get exclusive rights to plumbing by themselves, which is fine. You're going to get Joe's Plumbing, probably not, because it's the next one is descriptive. Not favored. Holiday Inn or Bufferin, those are descriptive. Bufferin might be something that would be considered good. But here's why you want to maintain, and this is the best reason. Let me just, a generic something. So if you don't maintain your brand, then you lose it. So you know how I told you that trademarks, it's 10 years from when you register, you have to keep registering it. There are some that have become so generic because they didn't protect them, and we'll talk about that in a second, like nylon, zipper, thermos. They were lost because they didn't protect them. So part of intellectual property isn't just about registering them. It's about protecting them. Your exclusive right to them comes from your willingness to protect your brand. That's why, for instance, Martha Stewart, if you infringe on her brand, she will sue you. Apple, same thing. Everyone should enforce their intellectual property rights. That's how you prevent knockoffs, right? That's how you prevent someone from stealing your intellectual property. You have to be willing to protect it via litigation if you need to. If nothing else, by indicating that you will litigate, cease and desist letters, so on and so forth, you're going to want to make sure that it's protected by enforcing it and through the litigation process if you need it. Like, honestly, a cease and desist, if you can get away with it, is the easiest way to do it, but you're going to want to send that every time. You're not going to want to just, it's a little thing, not going to worry about it, because otherwise you lose those protections. Not only if you don't register it, but if you don't enforce it, then you'll go the way of nylon, zipper, and thermos because they didn't protect their brand. And that's really what it's about, which is why Apple is worth as much as Apple is, which is why Nike is worth as much as Nike is. Reebok. All of these really big companies are worth a lot more money because they were a brand than if they were just a shoe company. Okay. Or if Reebok was, oh, those are Reeboks and everything's a Reebok, right? I mean, think of like a photocopier. Okay. Photocopier is what it does. Xerox is the brand. But a lot of people just call them Xerox, right? Or tissue, right? Kleenex. Hey, can you get me a Kleenex? Okay. Kleenex is the brand. Tissue is the material, right? But if someone's stealing Kleenex, okay, but it's almost become ubiquitous, right? People use Kleenex interchangeably with tissue. Nobody thinks about it. Jacuzzi versus hot tub, right? Jacuzzi is the brand. Hot tub is what it is. Okay. Jacuzzi has to work hard to protect their brand. That's how they continue to be able to sell jacuzzis at a premium over hot tub that is just a type of thing. Okay. So these are all things that you need to consider when you are working on protecting your brand, which is why it's so important that you worry about your intellectual property. You don't just sit on it and wait and hope for the best, because unfortunately, there are, like I said, copyright trolls, patent trolls. There's a lot of things coming at you. If you're truly serious about building a brand, you can't just let whatever happens. your value, and we've talked about this in other instances, in selling your business, as one of the values is your intellectual property. It will give you a better return on your investment because you are selling a brand, not people are going to buy Rescue Rooter, not Joe's Plumbing, right? People are going to buy Apple because it's Apple, not Joe's Computer or whatever. You know what I'm saying? So if you're building a brand, you're going to protect that brand first and foremost. And then also you have to renew things. So don't forget that these are important things to start the process now. Today, even, not next week, not next year, now. You're going to see the best result by protecting, especially intellectual property today. There's nothing worse than, putting it off until tomorrow, hoping for the best, and then you end up with, oh yeah, by the way, you don't get to protect your intellectual property because somebody else did it. That's the sad, true reality. And I see this all the time. So that's why I want you to do it today. Call me, chat, put something in the comments, whatever. See a local intellectual property attorney. If you, I don't do patents, but I can find you a patent attorney if you needed. But keep that type of thing in mind. Today is better than tomorrow. This isn't, yesterday was better than today. This isn't something to put off. So, if you've gotten value out of this video, don't forget to hit subscribe and like for future videos. Hit that bell icon to be notified of when I go live. I'm like I said, I'm here Monday through Friday, except for holidays, to help you with your business. So please tune in. Feel free to ask questions, chat. I'd love to know where you're from and questions that you might have. And I hope you have a great day. We'll talk to you soon. Talk to you tomorrow. Oh, by the way, we're going live on Facebook tomorrow.